Hello, my name is Hae-Sung Kim, advisor of Gangnam Labor Law Firm. Today with Labor Attorney Jung Bo-soo, we will cover a particular case that recently Dr. Jung Bo-soo has provided regarding the part-time employee, and it can be concluded as an unfair dismissal case. So could you explain in detail about this case, please?
Hello, how are you today? This is Bong-soo Jung, Korean labor attorney. So this morning I had two visitors, and they are my friend, and his wife has some problem. His wife was terminated. He was fired June 8th. So she worked for the restaurant for 4 months. So she didn't have any employment contract, so she repeatedly asked the employer about some issue, the employment contract. Then employer gave some employment contract, and it was actually there was no fixed term, but they have a fixed term period. Also, after 3 months, also 1 month later, the contract started February to May. Then she worked 1 month additionally. Then they fired her without any justified reason. So they fired her verbally. So in this case, this employee asked some how she could receive unemployment benefit. Also, how could we receive some the non-notice allowance, non-notice dismissal allowance. So I told her, I think that should be important issue. However, you have to focus. So they have not registered this employee for social insurance. So legally, she's not entitled to any employment insurance. So how to get the unemployment benefit and compensation is she must take legal action through Labor Relations Commission. She should file the unfair dismissal application to this commission. Then when she wins this case, she can receive compensation plus some unemployment benefit. So this is how I explained it. So then in her case, she worked for the restaurant for 4 months, and she worked from Monday to Wednesday, 8 hours each day. So she worked there for 24 hours per week. Also the contract was 3 months, but she worked 1 month additionally. Also, she was not registered for social insurance. So in such a case, how she can get some compensation, also unemployment benefit. So I explained to her, I think you are not registered, and company has not contributed some premium for those social insurance, so you are not entitled. So only you can receive is non-notice allowance for dismissal. However, this small amount, so you have to focus on dismissal cases, and you can get some compensation. Also, through this the unfair dismissal case, you can apply for unemployment benefit to the job center. So when they judged you were employed, then they will give us some correction order to the company, and the company should retroactively pay all unpaid premiums during her employment period. So in her claim for unfair dismissal, she should prove this restaurant only has 2 employees registered for social insurance. However, there are more than 5 the part-time intern workers, so they have not registered for social insurance. In such a case, you have to prove how many people had worked there that period, just before 1 month period, before the last day of her working day. So Also, she must prove that she was fired without any written notification. So written notification is important in case of termination. So according to Article 27, when employee intend to fire people, the employee should issue some written notification that must include the reason for termination and effective date. So this written notification is mandatory in case of judging the dismissal case. Yeah. So this is how I advised. So I think this restaurant owner didn't know anything about the labor law. So they must respect the law according to the labor standard. Without that, they have to pay compensation. Also, they have to also they have to retroactively pay their premium for social insurance, even though they regarded those intern workers as the freelance or the personal contractors. So actual relation is important in this case. So when I make in summary, so number of workers is important for application of unfair dismissal, at least 5 workers or more. So in this company, there are many intern temporary workers, but who have not been listed for social insurance. So they all should be included in counting of number of workers there. Yeah.
I see. So this, as you said, the owner of the restaurant, he has no knowledge, not much knowledge of labor law. So even he dismissed this part-time employee without a written notice or reason for any termination. And you have indicated that although the officially registered workers are 2, there are more than 5 workers, and these people, these part-time workers also should be subscribed as national insurance.
Mm-hmm.
So this dismissed employee, you consider that she or he is entitled for the unemployment benefit?
Mm-hmm.
Yeah?
Yeah, in order to be a qualified company should register those social insurance. Also, the company has to pay the premiums for social insurance, but they have not paid. So, however, the labor law translates them as employee. So, when the labor commission judged it was unfair dismissal, it is strong evidence that company should submit the unpaid premiums during the maybe whole working period. Yeah.
So this kind of part-time workers, maybe they are very utilized shortly by the employer, and because the employer doesn't know much about doesn't have the knowledge of labor law, he considered that this is just a simple dismissal case without giving her the compensation
So,
for the work that they have done.
Yeah, I think in this case, in order to be a justified dismissal, employer should issue a written notification that should include reason for termination and effective date. So, but employer neglect to issue that. So this is a very strong case. Even though she worked the 3 days per week, and each day she worked 8 hours per day, then it was 24 hours per week. So, but still, she is eligible for applying for unfair dismissal case. But the company that hired a person less than 15 hours, then then in such a case, it's hard to apply for the remedy claim for unfair dismissal because their working hours very short. Yeah, according to Article 18 of the Labor Standard Act. Yeah.
I hope that she will be eligible for the unfair dismissal and the compensation.
So
from the Labor Commission.
this case I explained her. So she must go through Labor Relations Commission, especially Seoul Labor Relations Commission. So she must visit there and register for unfair dismissal case. Also, she should apply for government-sponsored labor attorney. Then she will not pay any legal fee. So this is what I advised her. She should follow. Yeah.
Thank you very much for your comment.
Okay, thank you for watching. Okay, bye bye.